Greetings and welcome to the Privacy and Data Protection in 2020, what your business needs to know. As a reminder, this conference is being recorded today, Thursday, February 13th, 2020. I would now like to turn the conference over to Gina Bryant. Please go ahead.
Welcome everyone, and thank you for joining us today. My name is Gina Bryant. I'm going to be your webinar facilitator today. Just a few quick announcements before we begin. Today's webinar is brought to you by Corp Magazine and the Best and Brightest Companies to Work For. As mentioned, this program is being recorded and will be available to view starting next week on Corp Magazine and the Best and Brightest Companies to Work For websites. If you are on today's call for continuing education credits, please make sure to complete the SurveyMonkey evaluation that will be emailed to you later on this afternoon. Today's webinar is eligible for 1 hour of SHRM or HRCI credit. So let's get started. Today's webinar is Privacy and Data Protection in 2020, what your business needs to know. Our presenter today is attorney Jeffrey May from Kerr, Russell & Weber. Jeffrey practices in the areas of general business law, intellectual property, and litigation with a focus on the increasingly important area of cybersecurity and data privacy law. As part of his practice in the area of cybersecurity and data privacy law, Jeffrey helps clients identify and mitigate risks related to data security incidents and breaches, information technology policies and practices, and data sharing arrangements with third parties. If you have any questions during this webinar, please use the chat feature in your lower left-hand portion of your screen. We will get to these questions either during the broadcast or after the broadcast. I would like to now turn it over to Jeffrey so he can inform us on what our businesses need to know to keep our privacy and data protected in 2020.
Oh, thank you, Gina, and good afternoon, everyone. To follow up on what Gina said there, I want to let everybody know, just for a little bit of context, I've been in the information assurance area for about the last 15 years, on and off. I say off because I took some time out to get my legal education and then moved into this area of data security and data privacy. And one of the things that I've found in this area, it goes back to the old adage of you don't know what you don't know, right? So, people talk about data privacy, they talk about data security, and there's always a misunderstanding of the difference between the two. So that's one of the things I want to focus on today. As we move forward, this is going to be our agenda for the day. We're going to talk a little bit about that difference between cybersecurity and data privacy. We'll talk about the data privacy outlook for 2020. Touch on some cybersecurity threats. We'll go through some examples. And one of the focuses, too, is going to be the cost of a breach and how to mitigate that breach, how to mitigate the loss to a business when there is a cyber breach. Because if I were to stand here and say that there's a way to make your business 100% secure, I think all of you are going to understand that that's just not going to happen. So how do we mitigate rather than how do we completely avoid? And finally, we're going to talk about how do you build a framework to address these issues in cybersecurity and data privacy. Now, I'll start by saying, typically when I give presentations like this, I love to be in a big room with an audience, and I love to have my slides go through with some animations. So for right now, I'm going to ask everybody, please ignore the big red X on the screen. That'll pop up later, and we'll talk about that. So let's start with this question. When I say data privacy, what comes to mind? Now, if we were in a presentation with an audience, I'd have you give me some examples, but inevitably what's going to come up are things like cybersecurity, hackers, viruses, identity theft, malware. Those are the things you think about when somebody says data privacy. It's natural because you think data, you think privacy, and your mind automatically goes to the negative. What are the bad things that can happen with the data that I host? Well, now pop up that big red X, because those are not the things you want to think about when we say data privacy. What I mean by that is when I say, what do you think about when I say data security? It's probably those same things, right? So this is where we have a distinction. And as I noted, it's an often overlooked distinction. So let's put this into context. Think about the information that your business collects on a daily basis. Maybe it's things from customers, things like their name, address, social security number, commercial data, things like what purchases those customers have made over time, educational and employment data. Maybe you have resumes on file, things that you store. You scan those resumes in, you put them in your system, now they're electronic documents. Now take a minute to think about how your business secures that information. What kind of security controls do you have in place? It's going to vary from business to business, but inevitably you've got something on the border of your network like a firewall. You've got things internally to avoid access. You've got virus protection. You've got malware protection. That's all on the data security side. Now think about how your business actually uses that information. Maybe you keep that customer information on file so that you can contact your customers. Maybe you keep their purchase history on file so that if they log into your website, you can say, here's what you've purchased in the past. Do you want to reorder? Or maybe that just happens with a phone call into your business. Regardless, you have reasons that you have that information. Now take a minute and think about how else you might be able to use that information. Things like maybe selling it to a third party, mining it for other information. Do you have the right to sell it? Well, that's where we get this quote up here on the right. You can have security without privacy, but you can't have privacy without security. And that's a general saying that in the data privacy area. So let's put those two together. You've got all this information. You know how you keep it secure. And obviously, if it's insecure, if somebody hacks in from the outside, that privacy is gone, right? But think about the corollary to that. You've got this information there. You keep it secure. No one accesses it. Nobody comes in from the outside. But you start using it in a way that your customer wouldn't approve of. You don't have a data breach. You don't have a security issue. You've got a privacy issue. And that's where the distinction comes in. So let's dive into that for a minute. What is data privacy? Well, in general, we're concerned with the proper handling and access of data. Unlike IT issues, though, this is primarily driven by legal issues and customer expectations. So looking at it from a security perspective, you're usually thinking, how can I secure this data? I'm worried about a breach. I'm worried about what's going to happen to my company if that happens. On the privacy side, you want to think about your legal requirements, and we'll get into those a bit more today, and what your customers actually expect. And I'll tell you today, customers have a much higher expectation of privacy in their data than they did a few years ago. More importantly, though, privacy is cross-functional. It goes well outside IT. It hits IT, legal, compliance, sales and marketing, HR, operations. Every part of the business is going to be involved in your privacy plan. So what are some things that the business needs to focus on? Well, your privacy policy and your privacy notice are probably number one. There's a distinction there. That's something that I think everybody should be aware of, that generally in the industry, a privacy policy is what you're going to see on a website, but that's really incorrect. Your privacy policy should be what you have internally. How do you use customer information? How do you use employee information? And you're going to disseminate that among your internal workers. This is what we do. This is our privacy policy. Your privacy notice, on the other hand, is what should be on your website. This is what's out there. This is what we're telling our customers. This is how we're going to use your information. They're going to parallel each other, of course. Everything that's in your privacy policy is likely going to be discussed in your privacy notice, but the way those are drafted and how they have to be tailored makes a big difference. You also need to focus more on customer rights when it comes to data privacy. This isn't just about protecting information. It's about what the customer rights are and how you use that information. Another focus, it's a couple of years ago more than it is now, but cookie compliance. These data privacy laws that we'll talk about, most of them have requirements of how your website can track users and what you have to disclose to users and what information they will allow you to use. Those controls have to be in place. So really what it comes down to when we're talking about data privacy is you have to think about notice, transparency, and proper use. How are you using the data? How are you telling your customers that you're using the data? And are you going outside that scope? So let's talk about why for a minute. I don't know how many of you, again, I'd have you raise your hands if we were in an audience, but I don't know how many of you heard about the Facebook Cambridge Analytica scandal. I would imagine most of you have. If not, I highly recommend checking out the Netflix documentary, The Big Hack. Very interesting, very enlightening, and if you haven't seen it and you watch it, you'll probably be afraid to go online for a few days. But to break this down into what it was in a very short version, Facebook essentially collected customer data, things like when you visited, your different likes, comments you made, groups you were a part of, and they sold that information to Cambridge Analytica. Cambridge Analytica then used that information to create targeted content that actually focused on your subconscious biases to affect how you're thinking. Now, from a psychology and marketing standpoint, to me, that's absolutely fascinating. But what I think everybody would agree on is that from a privacy standpoint, that's terrifying. I mean, how is my information being used? How is Facebook using my information? Who are they selling it to? What are they doing with it? What information do they have? And that's what all these data privacy laws are really focused on. Now, interestingly, as we start diving into them, you'll see the first one here is the GDPR. That's the EU's General Data Protection Regulation. It was enacted in 2016, and Facebook Cambridge Analytica didn't really hit until early 2018. So these laws were already moving in that direction, but the Facebook Cambridge Analytica issue really highlighted the need. We could spend a couple of hours talking about just the GDPR, but there's all sorts of webinars out there on that. There's all sorts of information to find in the GDPR, and it may or may not affect your business. So I'm going to try to move through these a little bit one at a time and not focus specifically on that issue. But you'll see I've got the CCPA and the Washington Act highlighted there. We are going to dive into those a little bit because for 2020, those are particularly important. As noted there, the California Consumer Privacy Act is the first comprehensive consumer privacy law in the U.S. I know some people will say that Maine was on board before that, but California really sets the standard. It was effective January 1st, so for those of you who need to be compliant with the CCPA, you're already too late, but it's never too late to start moving in that direction, especially because the California AG has said that enforcement will not begin until July 1st, 2020, and there's currently lobbying going on to push that back even further. But that doesn't mean that you don't need to comply until July 1st. So again, as we go through this, if anything pops up, if you start to think maybe I should look into that, it's certainly something you want to discuss with your legal counsel. There have been a bunch of new bills introduced in 2020 already. Florida, Illinois, Nebraska, New Hampshire, Virginia, and as I noted, Washington. Washington's highlighted because it's probably going to be the next to actually take effect. Federal legislation. This is a big one. Right now, there are competing bills introduced at the federal level. In general, they agree on 95% of what this should include, and it's going to be very similar to things like you find in the GDPR and the CCPA. Where there's a little bit of divergence is whether it should preempt state rights, so whether states should be able to give consumers more rights, and whether there should be a private right of action or it should only be enforced by the government. But I only mention that to say that even given all the political divide in Washington right now and all the gridlock that you see, there's a lot of agreement that this is necessary. So regardless of what happens in the election this year, regardless of where things go, this is going to happen, and most industry experts feel that it'll happen in the next couple of years. So even if you find that these various states don't apply to you, I know a lot of us are here in Michigan right now, even if you find that these don't apply to you right now, odds are there's federal legislation coming down the road, or at the very least, Michigan will jump on board at some point. Also, I've noted there's over 80 countries internationally that have their own privacy laws. And I should note that most of these are extraterritorial. So if you aren't located in these states or in these countries, you generally still need to comply with these regulations if you do business in those countries in any way. And the way we're a global market right now with online advertising and the ability for people to purchase from anywhere, usually you're doing business in one of these locations. I think this is also a good time to take just a moment to plug our new Kerr Russell Data Privacy newsletter. I won't spend much time on it, but if you want to stay up to date on these, feel free to drop me an email after this presentation, and I can get you signed up for that. We're sending out, it'll be a monthly newsletter on updates in data privacy law, changes in the area, tips, best practices, things like that. So back to the details. The California Consumer Privacy Act, as I said, I want to spend a few minutes here because it's brand new in 2020, and it's really where a lot of businesses need to focus. Even if you're not required to comply with this, most industry experts would recommend that it's good to take a look at it and consider where these regulations are going, because something similar to it will apply to you in the future. And it's a good idea to move your business in this direction now rather than having to jump at it at the last minute. So what does the California Consumer Privacy Act do? Well, overall, it governs the use of personal information. So what is personal information? Now, they define it as information that identifies, relates, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So thankfully, they gave us some examples, because if that's all they were to put in there, everybody would be scrambling trying to figure out what this means. So here's the list of examples. I'm going to touch on a few of them. Identifiers, name, alias, IP address. And that's a big one, IP address. Now, just last week, the California Attorney General issued some new regulations, and they clarified that IP address is only considered personal information if it can be linked to an individual or household. So if your business is storing IP addresses for any particular reason, but you're not storing any other customer information, this may not apply. Commercial information. This is why I mentioned earlier products or services that your customers may have purchased. If you have a list of customers and you associate those customers with particular products that they've purchased, well, that product purchase information is now considered personal information under the CCPA. Biometric information, so things like facial recognition, fingerprint, DNA, palm scans, retinal scans, all of that is considered personal information. Internet and other electronic network activity, geolocation data, so anytime you're tracking, whether it's a cell phone, if you've got an app that tracks where people are located, that's all considered personal information. Now, this next one I haven't personally run into yet, but audio, electronic, visual, thermal, olfactory, similar information. So if you have a system or for some reason you're tracking how people smell, what they look like, what they sound like, all of these different things would be considered personal information. Professional or employment related information, so those resumes you're storing online, those are considered personal information. And finally, my personal favorite, inferences drawn from the above to create a profile. Hello, Facebook. So this is specifically targeted at companies like Facebook that create profile information based on what they already have. So if Facebook has created a profile on you that says, you know, you tend to lean a particular way politically based on the groups that you're a part of and the way that you interact on sites, that profile that they have created, even though it's not information you gave them, is considered your personal information. And this will all be important when we talk about obligations in a couple of slides. So who does the California Consumer Privacy Act affect? Well, businesses that do business in the state of California, and that is incredibly broad. If you have a website that reaches California and consumers can purchase information or submit information to you from California, then you do business in California under the CCPA. A business that collects personal information. Well, if you're collecting information from people, it's pretty obvious. You determine the purpose or means of processing. Essentially, what do you do with you decide what you do with the information or how it's collected. This is where I think a lot of people breathe a sigh of relief. You only have to comply with the CCPA if you meet one of these three requirements: gross revenue in excess of $25 million, information on 50,000 consumers, households, or devices, or at least 50% of your revenue is derived from selling that consumer information. Now, I will add that the term selling is defined incredibly broadly under the CCPA. It is any transfer of information to a third party for valuable consideration. There's a lot of debate right now about what that means, and the California AG is trying to clarify it, but we're going to learn that on the fly over the next couple of years and how the AG tries to enforce this and what's considered selling information. So what is the effect of all this? Well, they're not trying to focus on small businesses. If you have a small business, even if you touch California, they don't want you to have to comply with this because it can get pretty onerous. And here's what I mean by that. California Consumer Privacy Act creates 4 rights for a consumer in general: the right to notice, the right to knowledge and access, the right to deletion, and the right to opt out of sale. So what do those mean? The right to notice means you have to provide an explicit, clear notice, quote, or before the point of collection. So when you're actually collecting that information, the customer needs to know the categories of personal information that you collect, how and where that information is collected, the purpose of the collection, and also whether and to whom that information is disclosed. So when you pull up a privacy policy for a California company now, or a company that does business in California, you'll see a full section on California consumer rights. It'll lay all of this out, and it'll say exactly what categories of information are collected, how it's collected, where it's collected, why it's collected, and how the person can exercise their rights. They have a right to knowledge and access. That means if you, say for example, you're Facebook, and you collect all sorts of information, and you create all these profiles about people, I as a consumer have a right to send a request to Facebook to say, what information do you have on me? I want to know specifically what you have. And they have to respond to that request. They have to provide me a list of all the information they have and all the details on it. They have to do that within 45 to 90 days. They can request an extension. But if you think about it from a business perspective, that's actually a pretty onerous requirement. I mean, now I have to, as a business, I have to have a process in place that allows my customers to contact me, request the information I have. I have to be able to pull that together in a relatively short period of time and send it back out to the customer in a secure format. And we'll talk about how some companies are doing that in a minute. The right to deletion, pretty straightforward. The GDPR has something similar in the right to be forgotten. Essentially, if I contact a company that's governed by the CCPA and I want my information deleted, they have to delete it. Everything has to be cleared out. There are some exceptions to that. They can keep anonymous data. They can keep data for research purposes, but it's somewhat limited in scope, and they have to notify me that they're keeping it. And finally, the right to opt out of sale. If you do sell information to a third party, and again, that sale is defined very broadly, customers have the right to opt out. Under California law, they actually just released the logo for it. It's a little red button. But you have to put that little red button on your website in a conspicuous location. The consumer has to be able to click on it, and they have to be able to send you a request to opt out of the sale of your information. So what are some of the things businesses have to consider when they're looking at this? Well, how do you respond to those consumers' requests? You know, if a consumer wants to exercise those rights, it's not enough for you to say, oh, just email me with a request. There are specific requirements that are put in place. You have to update your vendor and service provider agreements. Now, this is a critical point that a lot of people miss when it comes to the CCPA. If you have a third-party vendor that you work with and you're transferring customer data to that vendor, there's an assumption that, oh, well, I'm governed by the CCPA, so of course anything I send to my vendors, they have to comply with the CCPA too. Well, let me give you an example of where that might not be the case. Let's say you're a large corporation, you've got 25 million in sales, you touch California, you do business there, so you're governed by the CCPA. Your vendor is a small company in Michigan, say 5 million in sales, and they don't do business in California. Well, technically, they're not governed by the CCPA. So what the CCPA does to correct that issue is anyone who's governed by it is required to include specific language in their contracts that bind their sub-providers to the same types of requirements as the CCPA does. So if you as the main entity gets a request for what information is held and how it's used, you can pass that request on to your provider and they have to respond to you, and you can pass that information back on to the consumer. So updating all vendor agreements, service provider agreements is critical right now if you're governed by the CCPA. What you may also see as a business right now, you may see these agreements being pushed down to you. If you're a provider, for example, if you're an auto manufacturer, or a tier 1 supplier, for example, one of the OEMs may push an agreement down to you that says, you need to comply with all these terms because we need to comply with the CCPA. That's being sent now because of these new requirements. Businesses are going to have to draft and revise internal policies. If you don't have a policy in place to manage and govern your data, you're going to need to get that in place relatively soon if you're covered by the CCPA. And of course, you have to update your external privacy notices. So the Washington Privacy Act, I'm going to touch on this a bit, not nearly in as much depth, mostly because it's not in effect yet and there's still some changes that could be made. but it's expected to be signed this year. It's similar in scope to the CCPA and the type of information that it governs. One of the big differences is that right now, it only looks like it's going to govern companies that have over 100,000 consumers and derive 50% of their gross revenue from the sale of personal data. But still, these are the types of regulations that are coming. Now, what's interesting here to point out is that there are different obligations for the business and different rights for the consumers. They're not identical. So, for example, if you look at those rights, you've got the right to correction. Unlike the California Act, where individuals can call up or email or request, what information do you have, and you have to answer it. Under the Washington Act, if any of that information is incorrect, you have to be able to go into the system and actually correct it if the consumer notifies you. There are also additional obligations for the data controller. For example, you actually have to have an internal process to appeal to a refused customer request. And you have to have data protection assessments in place. You have to have a policy for that. Also, unlike the California Act, the Washington Act does not include a private right of action right now, so only the California Attorney General can enforce. Now again, that could change, but we don't know what's going to happen in the next few months. Now, I bring all of this up to point out that privacy laws vary from state to state, and enforcement and fines can be huge. We don't know where these privacy acts are going to go in the U.S. yet because none of them are being actively enforced, at least until July 1st. But as an example, the GDPR has been around for a little under 2 years now. There's been over 400 million euros in fines that have actually been assessed to date. So these aren't insignificant numbers. So here's a quick look at where we are state to state right now. I say right now, but I have to amend that a little bit. You can see I circled Washington up there. When this map was updated, Washington wasn't as far along as it is right now. Also, Arizona has now introduced the new Privacy Act. So they're coming online pretty quickly. Most of these will be in place, if not this year, then in 2021 or 2022. So these are coming down the road and they're coming quickly. Each of them will have different privacy rights. There will certainly be some crossover, but depending on which states you're in, you need to be really careful to make sure that you're complying with all of them. Notification requirements, additional company duties, all things to consider as you move forward. So what role does IT play in this, and where do we start talking about security? Well, data mapping is critical. One of the things that I tend to run into early on when it comes to these data privacy issues are companies say, well, we have data, but it's stored in different locations. I don't really know where it's sent. Yeah, we send it to this provider, we send it to this provider, but nobody's really gone through and done a full data map of their internal data to see exactly where it's coming, where it's being stored, where it's going. If you're going to be able to respond to these consumer requests and you're going to be able to tell consumers where their data is coming and going from, you need to have that internal data map in place. Data security is obviously huge. As we noted, you can't have privacy without security. Policy enforcement. Policy is a lot of times enforced by compliance, by HR, but obviously there's an IT function there as well, especially if it's an IT-focused policy. Consumer request response, they can be involved in that. Incident response is huge. And I'm not talking about necessarily breach notification. You can see that at the bottom. But incident response is one of those things where if you don't have a plan in place in advance, you're going to have major issues. What is an incident? It can it can vary depending on the type of data that you have, where it's stored, how it's stored, and the response is different. But if you get a call at 2 o'clock in the morning from someone in your IT department that says, we think we had a breach, you're going to wish you had a plan in place if you don't already. Doing forensic analysis is obviously something that your IT department can get involved in. However, I would recommend using a third party where necessary, if only to avoid any questions about chain of custody or issues related to that. Third-party forensics can really help with that in the future. Data recovery, making sure that if you do have a breach or a loss, you have a way to recover that data. And finally, breach notification. Every one of the 50 states right now has a breach notification law. So if you have a data breach of some kind at your business, you want to reach out to counsel to make sure that you respond to that appropriately. There are scenarios where you don't have to notify consumers. There are scenarios where you do, and it varies state to state. So let's talk about the fun part, cybersecurity threats. If you've got this private data, if you have data stored in your systems, where might these attacks be coming from and what can you watch out for? So the top 5 that I've got here over the next 2 slides are the most common. They're the things that people think are going to continue being the top 5 over the next few years, and some changes that are going on in the industry. Phishing and social engineering are obviously going to be number 1. That's the target every day we get these. You can see 3.4 billion phishing attempts sent out daily. A lot of those are caught by antivirus software, malware software, but not all of them are. We all know that. You probably get these, each of you, on a daily basis. Well, let's talk about some specific ones, in particular how creative some people are getting and where some of these threats may go. So phishing, I don't know how many of you have heard of that, but it's essentially voice phishing. It's using the phone to hack into somebody's account. I'll give you an example. You've got a business, gets a call late on a Friday afternoon, says, I'd like to speak to Jim. You know, the guy knows that Jim's the company president. Jim's probably not around late on a Friday afternoon. He's told that Jim's not there. Of course, if Jim's there, he's going to hang up, but he's told Jim isn't there. Well, would you like to speak to Jim's secretary? Sure, I'd be happy to. She answers the phone. He asks her name. She gives it. He says, oh, you know, I'm a friend of Jim's. I just wanted to talk to him. Can you let him know I called? I'll call back next week. Okay. Hangs up. Relatively innocuous, right? Well, now this guy goes online, searches around for the secretary's name, finds her Facebook page, finds out that she attended Jim's daughter's wedding over the weekend or a couple weeks ago, downloads some pictures from her Facebook page from the wedding, embeds malware into those photos, sends an email to her saying, hey, it was great to speak to you earlier today. I forgot to tell you, I was at Jim's wedding and I got some great photos of you out on the dance floor. Here, take a look. So now she clicks on the photos and boom, malware's in the system, ransomware attack on the company, and they've got millions of dollars in damage. It's as simple as that for people to get into the system. And none of it seems fishy. But these are the kinds of things that you need to watch out for. Touch-based activation. I just heard about this one last week, and as much as I'm a security guy, I got to give the hacker credit. This is creative. Somebody received an email on their cell phone, and the cell phone had a white text background, or a white background with just plain text. It was just a general email, and in the corner there was a piece of fuzz. Well, that piece of fuzz was actually an image on the back of the screen, and when the user went to wipe that fuzz away on their cell phone, they installed the malware into their phone. Improved spear phishing. This is another one we've seen a lot recently. So I'll give you an example. Company receives an email from a supplier. Supplier says, you know, I have to apologize. I've got these 2 invoices that we meant to send you. I know we're a little late on it. Sorry about that, but I'm trying to close out by the end of the month. Would you mind paying these today? In case you don't have it, here's our ACH information so you can make the payment. I really appreciate it. Again, I'm sorry. You look at it, the email came from an internal source at the supplier. It came from their domain. Looks fine. It's clean English. There's no issues. We buy things from the supplier all the time. Okay, so I forward it on to accounting. Say, can you go ahead and pay this? Accounting goes ahead and pays it through the ACH information that was provided, and you're done. The next week, you get an email from the supplier that says, hey, we've got these invoices. Would you mind paying these? Put them in your monthly payment to us. Well, wait a minute. I paid these last week. You sent this out to me. No, I didn't. Okay, so now we've got a problem. Well, come to find out that a hacker had infiltrated the supplier's email system, found the invoices in the email, forwarded them on to the customer, and provided their own ACH information. Well, there's no way to find out that that was an improper email because it came in from the internal company. So malware's not going to detect that. Your malware detection isn't going to detect that. Your phishing scans aren't going to detect that. The only way to mitigate against something like that is to have internal policies in place to make sure that if there's a change in customer payment information of any kind, you have to verify that the customer is making that request by phone. You have to actually call up your supplier and make sure that they're changing payment information. I know it sounds like, this is basic stuff, but a lot of people don't have these controls in place because you don't think about these types of attacks. And finally, 2-factor authentication breaches. This one, it was one of those things I hadn't thought about, but it's coming up recently. You think of 2-factor authentication when you hear it as this is the secure way to go. If I have an account with 2-factor authentication, I'm secure. Well, not necessarily from a phishing perspective. So in these scenarios, what will happen, you'll get a call on your cell phone. They'll say, this is so-and-so from the customer service department at your bank. We've noticed some suspicious activity on your account, but thankfully, we know you have two-factor authentication installed, so we want to make sure that it's working properly and that you are who you say you are, and this is your appropriate phone number. So what I'm going to do is I'm going to text you the code for the two-factor. The system's going to text you the two-factor authentication code. If you can read that back to me, I can verify that you are the right person. So text pops up on your phone from your bank. It's the same place it usually comes from. You read back the 4-digit code. The person says, thank you very much. I've confirmed your identity. I appreciate it. Well, what was actually happening on the back end is the person on the other end of the line was hacking into your account online, and when it popped up and asked for two-factor authentication code, they just decided to call you and ask for it. So now you've provided that code and they've logged into your system. Again, watching for these things and knowing they're out there is really the only way to mitigate against it. So how do we do that? Regular training and testing is a huge one. Make sure that your company has training of personnel. And I don't just mean a 5-minute discussion at lunch. I mean, have a lunch and learn. Talk about this stuff. Bring in an expert to give these kind of examples so they know what to watch for. And testing. This is one of my favorites. There are tons of software programs out there that will send out test phishing emails where, unknown to your employees, they'll receive an email that's actually a phishing test. And if they click on it, your IT department gets a report that says, so-and-so clicked on this email, they need additional training. And you can build your training program around the people that are or are not clicking on these things. IoT-based attacks, that's Internet of Things. These are the devices you have in your house. So your Amazon Echoes, your TVs, your refrigerator, your microwave, your toaster, all these things that are connected to the Internet are inherently unsecure. Most of these things can be hacked by a good hacker in under a few minutes. So these things are out there, and if they're connected to your network, that's an unsecure point of entry that somebody could access through. So the best way to avoid that, segregate those on your networks. If you allow these types of devices at your office, put them on a separate network that people can use, and monitor your regular network to see what's connected to it. And if any of these devices connect, you should immediately talk to that person, disconnect them, and make sure they connect them to the segregated network. Ransomware attacks. Obviously, a lot of them come in through phishing attempts, but it's worth noting it's a separate high priority because they are so huge and they are so targeted. Right now, statistics show that about 4% of employees will click on any given phishing campaign, and that's likely to install a ransomware attack of some point. So it's certainly something to watch out for. One of the big things here, the best way to mitigate this is really disaster recovery. The only way to completely avoid a problem associated with ransomware is to really not care about it. If somebody hacks into your system and locks you out of it, you know what? Fine, I'm locked out. It's going to take me 24 hours to get my systems back up. Hacker, sorry, you didn't get what you wanted. I'm not going to pay you. That works if they're locking you out of the system and you're just trying to get access. Where it doesn't work is if they've downloaded your information and they're threatening to release it. And that's where insurance policies can be so critical. There's cyber insurance out there. The cost can vary depending on the type of information you have, but having ransomware policies in place where you may be able to pay that ransom and just move on can be critical. There are NIST standards out there on how to address ransomware attacks. Too much to go into in this presentation, but I would highly recommend taking a look at those and discussing them with your IT department. Data privacy rights compliance. I highlighted this because we talked about it so much today, and this is really a new issue when it comes to cybersecurity. If you are not in compliance with these different data privacy laws, the effect of a breach is substantially greater. And the best example I can give is under the CCPA. There is a private right of action under the CCPA where a consumer can sue you directly, either individually or in a class action, for essentially violations of the CCPA. However, the consumer can only sue under that provision if there's an actual loss of data and the data was not encrypted. So if you are properly encrypting data, properly storing it, and properly following the guidelines of the CCPA, you're substantially reducing your risk and potential exposure. But this takes, as I noted on here, a lot of collaboration between legal and IT. It's not something that one or the other can handle on their own. And finally, third-party vulnerabilities. Again, this is becoming more problematic as data privacy rules increase, but think about what happens if there's a breach with one of your service providers. You have all this personal information, you're sending it to a third party for some reason to process. It's a business purpose, it's legitimate, you're notifying the customers, but what happens if that third party gets breached? The best way to approach that is through the contractual requirements and regular audits. If your contractual requirements with your service providers require them to indemnify you for any issues that happen to pop up with your data that they're using, that's the best way to protect yourself contractually. Make sure your IT staff or your consultants can get in there and actually audit what they're doing. Make sure they're complying with the regulations. Make sure they're complying with your contracts. Try to protect your customer data with your third parties as much as possible. So what does it cost if you have a breach? Well, you can see it on the screen there, average $3.9 million, healthcare being at the top of the list, average of $150 per record compromised. So you can do the math for your own company and figure out how many records you have based on that cost. What could a data breach cost you? And then break it down to 67% of the cost in the first year. Now, what we tend to see is that companies look at this and they say, data privacy, cybersecurity, my IT department tells me we're secure. They say we're good. Well, let's think about that for a moment. Is your IT department going to say they're not doing their job? Of course not. And they probably are. They're probably as secure as they can be, but there's always risk. So taking the time to go through the proper procedures to do security testing, get audits done, put the right procedures, the right policies in place, do an incident response plan, get your disaster recovery set up, make sure you're compliant with applicable privacy laws. Those are all critical in planning for an incident. Now, this slide over here, this photo over here on the right is one of my favorites. I see it pop up every now and then, the budget before and after a breach. And it's really true. And how we kind of jokingly refer to that in the industry is post-incident, pre-incident planning. So we're not going to spend any money on this in advance of a breach because, well, that's a cost factor and we don't want to do that right now. We've got more important things to worry about. But once you have a breach, oh, you know what? Whatever you need to do plan for the next one, you've got it. You've got my support. And that's one of the things I'm trying to do here today is explain what these things are that you need to be looking at. So hopefully more of you will start implementing this pre-incident planning before the first incident rather than before the second incident. So what are some mitigating factors? Well, I've got the two primary ones on this slide. A breach response plan and team. Again, absolutely critical. That breach response plan, you should be doing things like tabletop exercises. That's where you'll actually sit down and practice what happens when a breach occurs. You go through it step by step. You've got everybody sitting around a table playing their roles, figuring out who calls who, when does it happen, when do we bring our lawyer in, when do we bring our IT people in, how does this all work? You practice it so that when you get that call at 2 o'clock in the morning, you're ready to go. And the reason that can be a huge mitigating factor is because it limits the scope of the breach and it gets you out in front of it as fast as possible. The extensive use of encryption is huge too. I know it's becoming more common today than it was, but really the cost of encryption is negligible balanced against the potential exposure if your data is not properly encrypted. So a list of other mitigating and aggravating factors. You can take a look through this. I'm not going to read through it one by one, but just some things to consider. Again, training is critically important. Cloud-based applications is interesting. In general, sure, cloud computing is secure. We try to secure it as much as possible. We get the right agreements in place. Everything's encrypted. But the more you put your information out there, the more you store it with third parties, obviously the more opportunity there is for something to get hacked. So I'm a proponent of cloud computing. I'm a proponent of cloud-based applications, but make sure that you're using them appropriately. System complexity is also an interesting one on this list too. You'll notice that that's listed as an aggravating factor. You can think of system complexity in terms of how complex is our encryption, how complex is our security, but really the harder it is for the people internally to know where things are and how they're stored, the harder it is to protect it. So the simpler your system is, the more straightforward it is, the more streamlined it is, the more secure it'll be. So what should you be doing? What are the things you need to look at to move forward in this area and protect your organization? Well, first, create an organizational vision or mission. So I'll give you an example. Microsoft's privacy mission reads as this. At Microsoft, our mission is to empower every person and every organization on the planet to achieve more. We are doing this by building an intelligent cloud, reinventing productivity and business processes, and making computing more personal. In all of this, we will maintain the timeless value of privacy and preserve the ability for you to control your data. When you put something out there like that as your mission, you're telling everybody internally that this is what we're focused on. Sure, we want to empower people. We want organizations to achieve more, but it's all under the guise of privacy and control of data. And when your company understands that you believe that that's part of your mission, all of this stuff will fall into place, and they'll start taking privacy and data security more personally. So what's your first step after that? Define the scope of your data privacy program. Figure out who the key personnel are. This isn't going to be all IT people. The people in charge of your marketing are critical. The people involved in HR are critical. All that employee data, how you use it, where it's stored, all of that matters. Identify applicable laws. Obviously work with your counsel to figure that out. Where do you have business? Where are your customers? It's not as simple as saying, we're not in California, so CCPA doesn't apply. Identify the in-scope data, and this is where data mapping is so critical. So choose a framework. There are several out there, NIST, ISO, generally accepted privacy principles, as opposed to GAAP that most of you have probably heard of. These are some things to look at, but they're just examples. Also, consider vendors with turnkey solutions. I mentioned this a little bit earlier, but a good example of this is my firm partners with OneTrust. We provide access to the OneTrust system as a way to work through some of these privacy issues. It's a technology solution. So for example, if a customer needs to comply with the CCPA and they want to put in place a data subject request process, systems out there like OneTrust, there's others, TrustArc, and a few others, that they'll put the system in place that's almost a turnkey solution where you can tell it where your data is, you can tell it what kind of data you store, and it drops a script on your website where customers can access it, make their requests online. All the data is provided through a secure portal, so it makes some of this onerous requirements a little bit easier on the business. It doesn't take it completely off your plate, but it's certainly helpful. Build a strategy for internal buy-in. Now, those of you who are on the call that are at the C-level and have control over your business, great. If you want to drive this down, that's fantastic. But for those of you who aren't, it's important to get buy-in from the executive level. You really need the organization as a whole to understand why this stuff is important and not just say, oh, it's data, our IT department has this secured. Your whole organization needs to understand how you use that data. And you might need to develop and revise your organizational structure a little bit. For example, if you do have to comply with the GDPR, there is a specific role that needs to be filled. There may need to be filled depending on certain circumstances, and that's the data privacy officer. So there are opportunities to put people in place at the right levels to guide the business through all of this. We've talked about developing internal policies, external notices, developing an internal training plan. Again, there's third parties out there that will work with you on those training plans. And develop and implement review and revision processes for all of this. Never assume that just because you have the information and you've done it once that you're all set. Especially with the changes in these different privacy laws, you really need to stay on top of this and review it probably semi-annually at this point, if not more often. So what's the takeaway from all this? Privacy and security are complementary, but they're not synonymous. Don't just assume that because your IT department has security experts that they're also privacy experts or that they know all these rules and regulations. They're organizational issues that go well outside of IT. It's going to continue to expand. Cyber attacks are going to become more sophisticated. Costs associated will continue to rise. And ultimately, doing all this is a time-consuming process. This isn't something you're going to put in place in the next 30 days, the next 60 days, or even the next 12 months. Depending on the size of the organization, this can take a substantial amount of time. But as always, there are professionals out there ready to help. I'm certainly willing to do that. And with that, if anyone has any questions, I am happy to answer.
Jeffrey, there was just a few questions posted. The first one being, as an expert in this field, how does this affect you as in your personal life, and how does it relate to social media security in your home?
Great question. As I've learned more about this, I have become a lot more cognizant of the privacy policies and the way that companies are using my data. To a certain extent, there are certain things you just can't avoid. I'm not going to stop using LinkedIn because I don't like LinkedIn's privacy policy, right? But I generally do avoid Facebook. That's a great example of what I've done on my personal life. I am just not happy with the way Facebook uses personal data. I've never been happy with their answers to some of those questions, and issues keep coming up, and you keep finding out that there are more problems. And that applies to social media across the board to fully answer your question. I think you, as an individual, you have to be very concerned about how these different platforms are using your privacy. And if you're not happy with it, you might need to walk away from that platform.
Okay, with the follow-up to that, what would be the biggest risks from using Facebook?
Well, I guess that depends on how you define risk. As an individual, if you're defining risk as, identity theft or something like that, well, it's no worse than it was before. Your data is out there online. Your Social Security number is going to be available out there online. I always take the approach of assuming everyone has my data, and it's more important to monitor my credit and monitor how things are being used, keep track of what people are saying about me out online, than to assume that I can protect it all. I think if you bury your head in the sand and assume your data is secure, you're really taking a huge risk there. But from a risk of personal data use, again, Facebook if they're going to use your data how they want, whatever information you put out there. I mean, when you play those games on Facebook, or you do the surveys, which house am I in Harry Potter, or which Hogwarts house am I in? You fill that out. Well, believe it or not, the answers to those questions can be used to build a profile about you. And Facebook may have an agreement with that questionnaire that Facebook can collect that data. So now they're taking all these answers and they're using them with artificial intelligence in the background to create an understanding of who you are as an individual. And the risk there, well, I mean, it's a personal question. Do you consider it a risk that somebody like Cambridge Analytica may be able to target you with biased advertising based on your answers to a Harry Potter quiz? I think that's a risk, but whether you care or not is a personal decision.
Another question that came online, how easy is it to implement these things as an independent insurance agent? Home-based business, sole advisor, etc.
Well, one of the key things there is an independent agent. One of the questions would be, are you really governed by these different privacy laws? As I would think you'd be considered a small business owner in that aspect, so you probably don't need to comply with many of these. However, there may be other reasons that you do. Going outside the insurance agent area for a minute, if you're a financial advisor, or if you are a single physician that owns a sole practice, you have HIPAA issues, you have GLBA issues. So there are different requirements based on your particular industry. To answer your specific question, how difficult is it to implement these changes? Updating your privacy policy can be pretty simple. It's very specific to your particular needs, but given the size of your organization, from what it sounds like, I would think it wouldn't be particularly difficult, but you'd want to talk to somebody who knows the area for sure.
Thank you, Jeffrey. I think that's all the questions for today. We do want to say thank you very much for hosting this webinar for us, and thank you to all those that came on and participated. Remember, if you do need any credit for your SHRM or HRCI, please fill out the SurveyMonkey that will be emailed to you later on this afternoon. As you can see on your screen, Jeffrey has left up his email address. If you need to get in touch with him, please do. He's willing to answer your questions. And again, I just want to thank everyone who participated today. I hope you have a great afternoon.
Thank you, everyone.